Recording in progress.
Ladies and gentlemen, welcome back to the main room of the second Bandung International Conference in Law.
Now, we are entering next session that is plenary session that will be led by our moderator. Therefore, let us introduce our moderator first. Ibu Diajeng Wulan Kristianti is a lecturer at International Law Department, Faculty of Law, Universitas Padjadjaran. She had finished her bachelor program at Universitas Padjadjaran. She also finished her master program at University of Geneva, Switzerland. She also finished her doctoral program at Universitas Padjadjaran. Ibu Diajeng Wulan Kristianti has so much experience, such as first, member of National Committee on International Humanitarian Law, National Consultant of United Nations Program Office on Drugs and Crime, Consultant at Indonesian National Counterterrorism Agency, Secretary of International Law Association Indonesian Branch, and Managing Editor at Padjadjaran Journal of Law.
More than that, she had published some book and journal. One of them is Hukum Pidana International Book at 2021, an article Penyelesaian Konflik Papua dalam Perspektif Hukum Humaniter, Pendekatan Militer Bukan Pilihan at 2021. And without further ado, to Ibu Diajeng Wulan Kristianti, the floor is yours.
Okay, thank you. Am I audible?
Audible.
Thank you so much. Okay. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, ladies and gentlemen. First of all, I would like to apologize for not being able to come in person to the sessions because due to my health conditions, I don't feel very well and I got flu and cough quite chronic. So if I speak longer, I tend to cough repeatedly and persistently. So to make everybody feel comfortable, so I decided to moderate these sessions remotely from home. But I hope that it will not make this session less interesting because we have fantastic 5 panelists with us today, and we have also a very interesting topic. As we probably know that the general topic of this international conference, the second Bandung International Conference, is law and post-pandemic. And for the special sessions, for these panel sessions, we are going to specifically discuss about the topic rethinking the law in post-pandemic world between adaptations and transformations. So each of our panelists will bring a very unique perspective regarding the challenges and opportunities presented by the COVID-19 pandemic in the current global context. And those will help us understand about this issue. So again, thank you so much for all of the panelists that we are with us today, and also for the audience for being here today. Okay, so this is how I will organize the sessions. First of all, I would like to give the floor to all 5 panelists, and I will reserve 30 minutes for the question and answer. So if I'm not mistaken, according to the schedule, we are going to have approximately 2.5 hours for the sessions. So then I will give for each of the panelists 15 to 20 minutes for the presentations, and then the 30 minutes for the question and answer. Okay, now I am so thrilled to introduce all of the 5 panelists with us today. For the first panelist, Professor Roy Andrew Partain. I am sorry if I mistakenly pronounce your name, but Professor Roy Andrew Partain. Yeah, he's with us today online. Good morning. I think today UK's time. Is it?
No, I'm actually in your time zone. I'm just north of you in Korea.
Ah, I see. Okay. So not really big time difference, yeah? In North Korea.
Actually, late afternoon here is 3 p.m.
Oh, okay. So it's still, yeah, It's still okay. Okay, so good afternoon, Professor Roy. So Professor Roy is a professor of international and comparative law and mathematical structure in law. So what a very interesting field in law. And Professor Law is a professor in the University of Aberdeen School of Law in Scotland, United Kingdom. And his current role is one of them is a strategic executive committee for School of Law. He is responsible for general management of School of Law and also a director of international research and joint funding, and also a lot of very important roles that I couldn't mention here one by one. And he's also written 6 books concerning mathematical models of law and international trade law and environmental law. So, Professor, I would give the first floor to you regarding this topic that we are going to specifically discuss. I have a chance to have a look to your presentations, and then it's also very interesting because if I'm not mistaken, you're going also to present your international joint research with Kobe in Aberdeen University under the UK Research and Innovations regarding an interdisciplinary study on medical research and development, rescuing international property rights in pandemic emergencies from the tragedy of the anti-commons. So I believe it's very interesting, and the audience so impatiently to listen to your presentations. So, and also you are introducing the anti-commons theory as your theoretical foundation. So please, Professor, briefly share your thoughts to us with regards to that specific issues. For the Professor Roy, the screen is yours.
All right. Well, thank you very much. I would like the audience to understand I'm basically going to introduce 3 ideas. First, that we are looking at this post-pandemic world from a legal perspective. The Japanese government and the British government have decided to spend considerable funding. There are 10 independent research teams, and the Kobe Aberdeen team is just one of the 10. We're all pursuing different theoretical approaches to getting the pandemic different and better next time. As we all know, in East Asia, we've seen these pandemics about every 5 years. We currently went through COVID, there was SARS, there was MERS, there's a variety of these things. And the Japanese government, I think correctly assumes that there will probably be another in the future. So we're looking to figure out a better legal response. Now, if I can share screen and make the technology work. I hope everybody can see that. Okay, so I misunderstood that I was going to have a longer time slot. So you may see on your screen that there's about 60 slides. I will go through this a little quicker so that we can get there. But the big question we're having from the Japanese government is, can we do better next time? Everybody had a tremendous amount of dislocation and discomfort. I don't mean the disease. I mean, all of the institutional and legal rules that happened made for a great chaos. And so we're trying to figure out how to do this better. So the Japanese government had a call, and there was this interesting broad perspective taken. Can we improve on policy, communication, speed up recovery and reducing cost? Can we influence the direction of recovery towards more equitable, inclusive, sustainable, and resilient in cultures, communities, and societies? And so what we were working on at Kobe and Aberdeen, we've been doing anti-commons research for quite a while. We were originally looking at housing and land in Japan, which has several major structural problems, one of which is there is a tremendous amount of housing or land that's not documented. Another is a tremendous amount of unoccupied houses. And we discovered this was an anti-commons problem. So we were working on this theoretical structure. And then the COVID provided us with a broad opportunity to get into it deeper. So we did propose our research grant, and we basically are looking, as the good moderator said, we're looking at anti-commons in the law. And I'll explain what that is in a second. But in particular, we said that we would investigate intellectual property law to investigate how the rights to control the use of patents, trademarks, copyrights might cause anti-common problems. This is at the bottom of the screen in underscoring. In addition to this academic significance, this research will hope to find alternative modalities and designs of intellectual property law that might be more responsive to emergency events and prevent the emergence of anti-common problems in various modalities of law. We have a very large research team. We have a research team of both British and Japanese scholars. We're also connected in with the British Institute for International Comparative Law, known as BICL, which sits in London. And we have some very strong heavyweights on intellectual property law from Abby Brown, Dr. Adebola, Professor Maniatis. We have quite a strong background in intellectual property from the UK. I'm not an IP lawyer, I'm the mathematical lawyer. So I'm bringing how to structure this mathematically. And then in Japan, we have several of Japan's top leading IP scholars. So we have about 17 people on our team. We did successfully get the grant, and to import, it's a large grant. It's worth about $850,000. And so this is just our one team, and there are 10 teams. And this reflects the importance that the British government and the Japanese government are putting into legal reform for the next pandemic. It's a very large emergency research push. So what are anti-commons? Is this economics? Is this property law? Is it IP law? It's actually everything. It's pretty close to everything in law. So the basic concept of an anti-commons, and I know the word commons, tragedy of the commons is somewhere in the back of your brain, but ignore that for the moment. Those are just fancy labels. But when you have two things that are both necessary to enable something subsequent, that is what we would refer to as, in economics, they'll call it complementary inputs. In law, we would refer to these as exclusionary rights, but they all come together that there is a decision point to allow it or to veto it. So for example, if I wanted to make bronze, I need copper and I need zinc. And Cournot, over 200 years ago, the French economist discovered this very unique problem when we have two monopolists competing with each other, against each other, to create another product that needs both of their inputs. This is actually far more pernicious, far more wasteful than just a monopoly, competing monopolies. And this concept was documented mathematically as early as 200 years ago by Cournot, and also by an American scientist, but I'll avoid naming everybody to save a little time here. So to get bronze, we need a copper monopolist and a zinc monopolist to approve inputting their product line into a second case. Now, what winds up happening if we need more? What if we need many necessary inputs? And every single red box there needs to be, yes, I'll allow it. The more red boxes you have, the less likely it's going to be that you get all of the necessary approvals to enable the next step. So we can look at the UN Security Council. We might be trying to get something approved by the Security Council, but there are 5 member states that have permanent vetoes, and they can just veto anytime they like. And so we need other people to vote to reach a majority or a supermajority, but these other 5 can just veto it. And because they do have that exclusionary right, they're able to stop the process at any time. Similar, what if we are developing a new medicine? And the new medicine requires technologies, IP, patents from medicines that already exist. And we need these patents to flow into a newer technology. Well, everybody who owns the previous patents have a licensing decision to make. Do I allow my patent to be used or not? Or perhaps even more critical, they're trade secrets. Very often the most important part in pharmaceutical industry is not the stuff that's patented. That's already public and everybody knows it. It's the stuff they did not publicize, the stuff they kept secret, their trade secrets from research, the unpublished reports. That might be the most critical thing necessary, is that somebody already ran certain tests, already has a pile of data, and that data would really accelerate the development of medicine, but because of the way trade secret law works, they may not be very willing to share that information. So we may not be able to advance medicine as quickly as we would like. So what are anti-commons again? I hope I've stirred an interest that they're relevant. Well, I'm going to give you two different approaches to define anti-commons. The first one really comes out of property law. Michelman at Harvard originally proposed this definition, but it wasn't until Heller clarified it about 20 years later that it caught on popularly. Under this definition, an anti-commons has a group of owners of a common resource. Maybe 5 families live around a lake. Each owner possesses an exclusionary right to prevent any other party from using that resource. So if you live in the valley where the lake is, and the 5 families all need to approve whoever is fishing on the lake, well, you need to gather 5 approvals. Unless all the holders of the exclusionary rights allow use of the resource cannot be used. So this is a very simple game. You have many people, all of whom need to approve the use of the resource or approve the activity, or else it cannot be accessed. And this is where the tragedy of the anti-commons comes from. The more people that there are that have these rights, these powers, the less likely the resource is to be used. Eventually, the resource is not used, and you have a social welfare loss for the community. It's very similar to the tragedy of the commons. In the tragedy of the commons, nobody has an ability to stop you using the resource. And the more people who know of the resource, the more people who try to use the resource, the more quickly it is fully exhausted and wasted. And again, social welfare loss, no one has anything to use. So the anti-commons is a little different. Instead of destroying all the fish, nobody gets access to the fish. And in many cases in law, you cannot see the fish. You might have a medicine that you need access to, but it requires accessing all of the patents or all of the trade secrets. And without unlocking all of the permissions, there is no medicine to see. And so anti-commons are often harder to solve than commons problems because they're harder to spot. There is another way to look at this, is the economic definition, which is that you have a process that needs multiple inputs to output a single result. This could be a decision, entrepreneurial, bureaucratic. It could be a kind of input, like it could be different parts of metals need to go together. It could be to have an iPhone, you need all of these different chips. And if some country decides they're not going to export their chips, then the whole iPhone cannot be manufactured. We call this kind of argument an input complementary. And unless all of the inputs are present and available, the process to create or enable output is not possible. So this is a newish theory for legal scholars, but it's been known to economists since the early 1800s. And in fact, from economics, from oligopoly theory, it spilled over into antitrust law about 50 years ago, but nobody called it an anti-commons at the time. So there are court cases and other instances where anti-commons are involved, but nobody called them that. So when the new name anti-commons emerged in the late 1990s, everyone's like, oh my gosh, this is new, let's think about it. And one of the things we've done for the Japanese and British government is actually to create a history of this idea. And we've gone back several centuries. Even Adam Smith wrote about it without giving it a label. And so we've now discovered there are many, many different aspects of social science that have discovered and rediscovered this concept. But keeping it very tight here, for legal researchers, the key issue is to realize that we traditionally create anti-common structures in acts of legal design. The creation of rights or the assignments of privileges usually overlaps with enabling anti-commons to occur, and thus enables the tragedy of the anti-commons to occur too. Now, I do want to remind folks there are some deep similarities to the idea of the commons, but they're kind of the inverse version. Because I'm saving time, I'll clip through here. It's interesting to consider what these inverse structures look like, and it's use versus exclusion. And so these two concepts are battling in the problems of the commons and the problems of the anti-commons, except they're reversed. Now I'm going to go through a couple of slides that give you a quick insight to what we know about anti-commons. Again, I'm trying to compress a longer presentation to a short one, so hopefully everyone will endure me. we've learned that the tragedy of the anti-commons shows up everywhere. Anywhere where you need multiple things to happen before a subsequent thing can, they're there. And in legal processes, this is all over the place. If you think about the number of things that need to click and occur in a coordinated manner to get a court case from beginning to end, all of that is basically creating an anti-commons that governs whether or not you'll have access to a judicial decision. We can also talk about anti-commons being involved in contract and licensing. It's quite everywhere. But at its core, it's very important to understand it has nothing to do with human weakness. It has nothing to do with psychology. It is the mechanisms of math. And I will not get into that today. I'd be glad to revisit with UNPAD later and give it much more detail. But everybody probably is already tired enough today. I'm going to skip this. I hope everyone at UNPAD has opportunity to see the slides. But we really do want to highlight to the Japanese and British government that we've discovered that anti-commons are not a tragedy, actually. They're really distributed governance. And by that, we can either design a legal structure to have a looser or a tighter sense of governance over a process or resource. If we want to protect an environmental reserve, the more we distribute rights of exclusionary rights to say, no, you cannot use that field or you cannot access those fish, the more we distribute it across the community, the more likely the resource is to be conserved and protected. On the other hand, we may not always want a rice field to be so protected. We want the rice field utilized. And so we would have less of the exclusionary rights distributed. We can see this in constitutional law. Would you like your constitution very flexible or very stable and conserved? If you would like your constitution conserved, then you want to distribute powers across the government that give many parties the ability to say, no, we're not going to reform the constitution this time. On the other hand, if you want a very flexible constitution, you can reduce the amount of exclusionary right holders and enable greater constitutional flexibility. So anti-commons are quite useful in a way that discussing the commons are not, because we're able to regulate, almost like changing the dial on a radio, how loud and how quiet. You can change how much governance exists and how distributed it is. Again, I was saying earlier that the idea of the anti-commons is quite ancient, and there are many different camps that have identified the same topic again and again. Although in America, it's most associated with Michael Heller and his research of the late 1990s. Sabellis actually hit it in political science about 10 years earlier, and much more mathematically and much more clearly. And he used it to describe comparative government and comparative parliaments, and was able to get quite far in explaining how governments work and develop policy stability. To give a little bit of a clue of where it comes in the law, there's a legal scholar, Bellantano, and I know I'm saying it wrong, I will apologize up front, but he gives some clear reasons why we will find legal anti-commons far more than people might expect. First, constitutional design usually distributes power, not only between different branches, between the judges, the legislature, and the executive, but also between the national, the regional, and the local and the city levels. Power is distributed across many different players, many of them with the ability to say, whoa, 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 not in my area or not in my topic. That means we're going to find anti-commons built into the nature of government. Also, he argues that it's kind of intractable. There's two other professors, Ko and Wang, who we'll discuss in a second, who discuss maybe you could just keep merging parts of the government and you would solve the problem. And honestly, Bellantano was able to provide why that won't work. Third, Bellantano makes it obvious that many regulatory decisions are not truly unilateral decisions. They're committee or distributed decisions. You have to reach across and talk to many people. Will you be okay if I do this? And because what you're doing is you're basically giving many people a soft veto. And sometimes in the law, it's a hard veto. Whenever you need that kind of group consensus approval decision, you're going to be creating an anti-commons again. Gao and Wang came forward to explain that when we talk about the property law definition of anti-commons, that the property notion in government-related services is quite different. As they say, what's really going on is The state acts as agents of the people, public organs who enjoy the right to exercise such power, to exercise exclusionary rights over the use of government resources, of government processes, of government rules and regulations. They are gatekeepers. And as such, they're exercising those rights on behalf of the public in their gatekeeper role. And so this research focus then turns to how and when agents of state power claim exclusionary rights or exclusionary control over the provision of public services, public goods, and related welfare. Again, I'll be kind of skipping through a tiny bit here. What I'd like to do is get to the exciting part of this presentation. This is where a lot of people will go, oh, no, this is not what I wanted. But I promise you, this is very interesting. And what we're doing is we're developing a new methodology for working with anti-commons and law in general. And this is to enable the Japanese government and the British government to ultimately redesign their laws much more effectively. So we're looking for decisions in law, particularly where decisions in law operate as gatekeepers, exercising some form of exclusionary control or exclusionary rights or exclusive control. And we see that across a wide array of rules. And that means when we see a cluster of decision points where there are these exclusionary powers being held, particularly by government agents, whether they be in ministries, in courts, we start to realize those are anti-commons. So we're looking for a variety of these anti-common environments present in our legal institutions and the operation of our legal institutions. So the key point here is we're looking for decisions, and decisions that are made by multiple actors, multiple voters. Is there a group of people that all need to input and feed in on decision processes over a legal process or a legal outcome? Do multiple people have to make it? Maybe we have appellate judges and we need 2 of the 3 at least to feed in with the decision, right? So we wind up with these issues. The ability to find anti-commons in legal processes is everywhere. So we're looking broadly to get something like this. What we try to do is we try to map what are the flows of the legal operations as we evaluate a pandemic policy response. Who is feeding what decisions? Each dot represents a decision point, and there's a lot of substantive law that drives the decision making. But then once the decision is made, where does the data from that decision go? Do they permit something? Do they prevent something? Do they approve or disapprove? Do they allow, not allow? And we can see across an administrative process or a litigious process or ministerial process, and often these are intertwined, these very complex pathways. So we're very focusing on what are the decision nodes and how do they connect to each other. We're very intrigued by how can we see how one legal act or one legal decision on an act leads to the next. Now, this is a lot of background. I hope everybody can read it at home. We might be trying to examine how much does it cost? And that's the Japanese yen, as we are modeling most of this in Japan technically. How much does it cost to achieve the legal outcome? So where is the most resources efficient way to get to the government's goal? If they're trying to save everybody from COVID, then there's 5 different ways. Which is the most efficient so they can save the most number of people? Or maybe we're worried about how quickly different administrative processes can occur. What are the different paths that an administrative process could take versus how many days it would take to reach the finish point? Or maybe we're worried about the success of the policy, and we could be looking at the probability. And mathematically, we could be looking at all 3 at the same time in 3-dimensional space. I won't go into that at the moment. Behind the scenes, what we do is we create these maps. Then we vectorize it. We say, where does decision point A, how many outcomes does it have? And what do those decision outcomes go to? And that leads us to step 3. And we can build this large chart. And then we remove the lines and we get this mathematical matrix in step 4. And I know most of you are like, I don't see law anymore. but all of law is still right there. All of those decision points reflected the substantive and procedural and the flow of it across it. And we can actually build similar graphs of how they make the decision inside of each node. Once we have a graph model like that, and the graph model is honestly that step 4. You might think a graph model is step 1, where you have all the circles and lines. It's really not. For mathematicians, it's step 4. That's where we're really excited, and we can start to do new techniques. We can start to look for best path, or we can look for complexity analysis. If you have legal rules that have a very complex network of interactions, maybe that's not a very reliable network. Maybe we want to look for canonical forms. A canonical form is where you say, here is a map that achieves a graph that shows how to get from A to B, but maybe there's a simpler way to do it, but have exactly the same rules. And we can reduce the complexity of the institutional processes without fundamentally changing the principles or the outcome choices of policymakers. So we can do that. We can also do comparative analysis. Once we can see how this process map might be in Indonesia, how the process map might be in Japan, how the process map might be in the UK, by using graph theory, we can do comparative analysis in new and innovative ways. So this is really quite important stuff. So will we be able to cure anti-comments? Will we be able to get a better result legally? Well, we believe yes, we will be able to. And we will be able to create new metrics to give policymakers insight into where law is likely to cause trouble in achieving policy outcomes. We can examine the decision nodes to see what's going on in each node. And maybe nodes take too long to resolve. Maybe nodes require too much information. Maybe nodes have an agenda that frankly cannot be done in realistic time. There's just too much going on there. And so we can identify, okay, this is where, when we're trying to get the administrative law process and it keeps getting stopped over here, we'll be able to identify that and analyze the why. We'll be able to make forecasts of where are we in the administrative process, what's going to be occurring in the future. And ultimately, if we build out these probabilistic models, there are already algorithms that we use in computer science all the time for doing the same kind of network analysis, like Dijkstra's algorithm, Jarnik's algorithm, Kruskal's algorithm. All these can now be applied to solve the administrative law problem. So we are now looking at ways to solve the problems, to avoid excess complexity, to avoid bottlenecks, or to places where alternative or extra new pathways might reduce the risk of anti-comments tragedies. Sometimes the best way to avoid the trap is just walk around it. Sometimes, like Alexander, you have to cut the Gordian knot, but now we'll know where the Gordian knot is. A few more cool things. We're discovering that law, everybody has always wondered, was there a better way to detail law, to capture law? Leibniz spent a huge amount of time trying to figure out a symbolic way to discuss law. Well, with what we're doing, we are finding that law can be converted into Boolean structures in a neat and tight way. Won't go into it deeply, but this could lead to other interesting innovations. As we get through this, it really comes down to what we'll call logical optimization, and whether or not complex systems can be reduced to simpler systems that take the same inputs and give the same outputs, but with much less complexity in the middle. If we could take law and simplify it in that way so that more people could understand it, the processes could be more transparent, the interconnections of law would be more transparent, that would probably be good for many systems of equity and justice. And finally, the ability to do comparative legal analysis would now have a totally new tool set that we are looking to use. So I will close my slideshow with this, that we are working very seriously to develop new methodologies, new research methodologies to enable the analysis of particularly administrative law as it applies to medical law, pharmaceutical law, IP law. And we hope that this will be able to spill over back into other areas such as environmental law and climate law. If we can use these kind of models to solve climate change problems, that might give us some hope for the future. Thank you. Thank you. I'll step back.
Thank you so much, Professor, for your very interesting presentations. I believe all the audience are very curious to know further and to also learn deeper from your presentations with regard to these new models and as to provide the solutions for all the problems causing from this, adaptation transformation because of this crisis. So thank you so much. And then move on to the second panelist. We have Professor Irena Kalbeli. I hope I pronounced your name correctly, Professor. So Professor Irena Kalbeli is a professor of law at Texas A&M University, University School of Law. So Professor Irene specializes in intellectual property, trade, and cultural heritage law. And then she has published around 10 books and more than 100 articles, book chapter, policy reports with regard to her field of specializations. And she is also sits on the editorial board of several scientific journals, including Oxford Journal of Intellectual Property Law and Practice, the Queen Mary Journals of Intellectual Property, and WIPO WTO colloquium papers. Well, Professor, I'm sorry because I don't have your presentations with me now, so I don't have a chance to take a look to your presentations. But I believe that you're going to also share your thoughts with regard to the challenges and opportunities presented by the COVID-19 in relation to your field of specialization, probably trademark law or intellectual property law. Because you have published numerous articles with regard to those issues. So Professor, you have 20 minutes to share your thoughts and the screen is yours.
So thank you very much. I hope you can hear me clearly.
Yes, loud and clear.
Okay, thank you very much. I want to extend my warm thanks to Pajajaran Unpad. I'm very sorry I could not be there in person. I really wanted to visit again Bandung, but it will be for next time. So I want to commend my fellow previous presenter because I think Professor Partain really did a wonderful job in presenting the study that has been done and question in many ways, not just the technology, but more, whether or not should be patented, but then the distribution and the theoretical basis, whether that should be protected or, we should have this discussion over commons or even anti-commons as his group is really interested in doing. I will not have slides. I will share perhaps a couple of graphs, but I want to focus my remarks without slides for once. I think we want to focus on what we are saying, not just what we are watching for once. And Zoom is very tempting to get a bit, we over Zoom in some way. And so the question, and I think this conference wants to answer, is what can the law do to help post-pandemic recovery? And in my specific fields, intellectual property, the question is, can intellectual property and to what extent help post-pandemic recovery? And so I think here there are two things that we need to very carefully look at. One is innovation output, and one is intellectual property protection. We too often think that one follows the other. They do, but it's not necessarily said that innovation output, it's because we have a lot of intellectual property before and after. Even though IP offices would certainly support, and studies done by IP offices try to demonstrate that a strong IP system does promote more innovation output. But in reality, it depends. And I think the question that now in a post-pandemic world, we are faced to try to resolve is, should we just keep the system as it was? Should we change it? Should we improve it? One thing that was very clear by all the discussion at the WTO, regardless the possible waiver of IP rights for the vaccine, and now IP rights for not just the vaccine, but all the medicines related to COVID-19, was really try to understand what to do in terms of public interest when we have an event so dramatic, such as the pandemic, and so many millions of people across the world might need resources that could be protected under exclusive right. There's been a lot of discussion over that at WTO, and eventually, as maybe you all know, a TRIPS waiver was adopted. But the actual version of the TRIPS waiver that was adopted was considerably watered down compared to what originally countries that proposed the waiver wanted to achieve. And here's the conundrum. The question is, will IP help promote more medicine, more innovation, and so on for future pandemics or for any day problem? Or should we find another way to redistribute necessary resources, such as a vaccine that was largely produced, not just with private initiative and private investment, but with a lot of public funds? Should we find better ways to redistribute these that might not be intellectual property protected or intensive? And I think, in some way, this question ties perfectly with our previous presenter presentation. And so what should be? Is a proprietary regime the answer to better products, more distribution, so fulfills more the needs of the population? Or it's a more open regime going to promote that further? And of course, the question, it's very difficult to answer this question. I think both sides of the, people might say we should have a patent system, very strong patent system to promote innovation. Others might say we don't really need it, particularly for medical and healthcare related or public interest related invention. Both sides can well use data to support their arguments. And so we are really left here with the question, is intellectual property necessary to promote innovation? Now, certainly, and here perhaps I share my screen briefly. You can see here a graph, and this graph comes from the publication which has been done by the USPTO, the European IP Office, the European Patent Office, and WIPO on the resilience and ingenuity global innovation responses to COVID-19. This is an interesting publication done by 3 chief economists and a colleagues, an academic in Europe, and provides a fairly unbiased review, because as economists do, it really counts applications, it counts patents, it counts type of application in which field of technology. And so the narrative that comes out of this study is certainly the IP system did work and was important for resilience of the economies, was important for the creation and the finding of the vaccine, and so on. But, and here is why I want to show you these slides. It's not necessarily true. It's not false, but we don't know to what extent is necessarily true, because we had a system that we applied. So we had patent system, the patent was implemented, and then companies, mostly through subsidy by government, released all these vaccines. In most countries in the world, these vaccines were given free to the population because they were paid by the taxpayers. But we don't know what would have happened if we didn't have this system established, and if we had to create another distribution, first creation and then distribution system. We have, even though I haven't, I didn't really do any specific research. We have what happened in Cuba. Cuba, of course, much more public system. the vaccine, Cuba created a local vaccine, a national vaccine, two national vaccines that seems to have very high efficacy. And those were distributed, of course, to the population. Of course, there was, very little protection over those. Those were really not exported in large quantity, however, outside. While the two vaccines that were mostly used, Pfizer and Moderna, they were protected. And as you might know, now there is a lawsuit, a patent lawsuit between the two. Moderna has filed a lawsuit against Pfizer in the United States. What is the intent of that lawsuit is still to be understood. Maybe it's a distribution agreement that Moderna wants to have with Pfizer. Maybe they want to go all the way down to litigation, to the trial. We still need to see. But there's been a lawsuit between the two main providers of the RNA vaccines at this point in one of the biggest markets, which is the United States. And so here you can see from the publication by the various IP offices that the patent application in time of crisis, and here you can see a variety of main historical crises, from the Great Recession to the bust of the online economies. You can see when we look at COVID-19, what happened was a drop initially in patent applications, more than what happened, for example, with other great, problematic events, disaster in our history. But interestingly, and again, these others in the publication show the response. And if you look at this slide, it goes all the way from 2019 to 2021, the second quarter. The response, of course, increases and more patents were filed, and in which sector of technology. And so what's interesting is, of course, pharmaceuticals and anything related to, pandemic management. Now, trademark applications. I have done a couple of empirical studies on who was trying to trademark COVID, for the marks, including the word COVID. And so trademark application in the time of crisis, with the COVID-19, interestingly, marks have been shooting up. And we have an increase in filings unprecedented. And all IP offices at the Madrid system through WIPO, that's been really interesting. So is that a renewed economic activity that is really trying to pick up, not just in the big patent intensive, but beyond that? And what's interesting is that when we look at the words, so this study looked at the words that were used in trademark applications. So there's been an increase in applications that have any relationship with medical products and medical services. Now, that might also mean, your coffee mug with the name of, the medical unit, because there've been a lot of these promotional advertising type of trademarks that have been filed. Our study did found an excesses of these really non-medically related applications using medically related terms. But still, this is really interesting. And there was a boom of application, not just fraudulent application. In the US, for example, we have a big problem with fraudulent application, mostly coming from China, that basically filed to clog the system. But there was legitimate application, whether or not then they were accepted, filing increased everywhere at the USPTO, at the European IP office, through the Madrid system, I'm sure, in the Indonesian IP office, and so on. So, and here, these were the slide I wanted to show you. So the question, again, it's, can intellectual property help in these instances? And this is a very broad question. And of course, I'm painting it with a very, very big brush here. Was intellectual property helping during the pandemic? We have seen that because economic activity was slowed down, a lot of IP was slowed down as well. On the other side, the finding of ways to get out of the pandemic was also depending. So new innovation, lots of R&Ds were spent during these months, during these couple of years. Lots of innovation was dependent on patents, depending what type of innovation, also on public funding. We have seen an uptick of all economic activity if more application on patent, trademarks, design means that there is more economic activity, which there is a direct correlation between the two. And so then the next question is the system as is working well enough to continue to promote innovation and a strong recovery out of the pandemic? The IP offices would tell you yes. I would tell you probably there are good reason to think that the system as is seems to facilitate more economic activity. I might not be as yes as IP offices might be, but it seems that yes, there is certainly more activity at the filing level, which let us presume, in the absence at this point of actual data updated, that people who are filing for patent, people who are filing for trademarks, they do have some economic activity, which helps economic recovery. Another very interesting area in which more activity is happening, it's in the green type of technologies, the green type of trademark, sustainability, because of course, we are coming out hopefully soon of the COVID-19 pandemic. The WHO director said that we can declare the pandemic over. Hopefully the end of the pandemic is in sight. The US has already declared the end of the pandemic, even maybe it's not yet over yet. But we are certainly entering one of the climax phases of the climate change problem. And we are seeing typhoons right now. There's a typhoon in the Philippines. There has been a major hurricane that hit Canada, and there is another one that is arriving to Florida today. And so climate change, it's here, real. We have never had past summer has been historically the warmer on record for countries all the way from China to Iceland. And this is something that it's very much the next disaster awaiting. And so we are seeing also much more attention to green technology, sustainable development, and anything that in the IP space can promote that. And so again, the question, and here, I want to leave the audience with this big question is, will the intellectual property system as we have it continue to promote or really helping lifting out of, the economic crisis that we have had so far? And Indonesia, it's a country that is developing more and more technology. Indonesia is rich in natural resources, but one of the richness of Indonesia is cultural heritage and agricultural products. When I come to Bandung, we go to the coffee plantation. We have, I know I'm very familiar with your agricultural products. You have, Batik Kumar and some of the best designs and batik of for example, of Indonesia. And so these other type of intellectual property, geographical indication, collective marks, certification marks are also very important tool for SMEs, for individuals, many of which happen to be women. And so, those who might not be in very patent intensive industry, that also proves that, there is economic activity. But here again, if there is an immediate direct connection, working with your DGIP, for example, in developing geographical indication, the question often is, will I have the geographical indication? Will I have more profit? Will I have more activity? And the question is, we need to have a good products first, and then the IP will put an exclusive right on people copying us in a way that is misleading or in a way that is misappropriating. And because of that, we can shield out unfair competition and continue to establish our goodwill and sell in the marketplace. But if we don't have a good product, to have all these shield doesn't really serve anything, because we are not going to sell, not because they're copying us, just because we don't have a good product. And so here, I want to, I don't know how I'm going with time. I think I'm about to reach the end of my time. I think it's important for us, and this is again is a big concept conference, and so I think we need to discuss big concept, and then we can look at the details, in our various offices. Is innovation, can intellectual property promote more innovation to take us out of the pandemic and help our economic recovery? Certainly, it's very likely that intellectual property can help. Intellectual property has helped with the medicine. We don't know, though, if a different system would have helped us the same. We exploited in the best way the system we had. And we just use, and we also know that the real issues with the pandemic and the vaccine was not really patents, was capacity building and infrastructure. Many countries now are creating their own national vaccine programs because they understood that even though vaccine were not a very profitable enterprise, they became a necessary enterprise. And many countries entered the COVID-19 pandemic without supply chains and manufacturing capacity for vaccines. While these might be always a problem for small, least developed countries, should not be a problem for countries as big and possibly with resources such as Indonesia, such as India, such as Bangladesh, and so on and so forth. And so many countries now are really rethinking national policies on vaccine and pandemic prevention. And here I leave you with the other very big question. Should we have an international agreement on pandemic prevention? We should. Will that be enough to actually help us if we have another pandemic? I don't think so. I think we need to have stronger national and even regional policies at the regional level with pandemic preparedness protocols, because we cannot think that the international agreements will fix the problems. We're clearly seeing that it doesn't. There was very much disagreement at the WTO, and when an agreement was reached was because the basis of that agreement were very, very, very low. So the threshold was still was very low. And so with that, I want again to thank you. I hope I was able to instill your curiosity on at least a couple of things. And thank you again for the opportunity. And congratulations to you all in Bandung for doing such a phenomenal job at Pajajaran for really raising the flag of this important issue in the country and abroad.
Thank you so much, Professor Irene Kalbali, for the very brief explanations with regard to the role of the IP in overcoming the negative impact because of this the pandemic, because you know that a lot of innovations that really dependent on these patents and also these trademark applications had a negative impact because of the crisis. And you said, yes, this IP can help to promote and overcome. And I do agree with your last statement that we do need the agreement, international agreement, both internationally and regionally, for this pandemic preparedness. Okay, so now we move on to our third panelist. We have Professor Susi Dwi Hardianti. Professor Susi is a professor in constitutional law, Faculty of Law, Pajajaran University. And also he's a head of constitutional law department of the law faculty at Pajajaran University. And today, Professor Susi will also discuss a very interesting topic with regard to the law post-pandemic. Professor Susi will discuss to what extent lawmaking in the post-pandemic era will make adaptations and transformations. For Professor Susi, you have 20 minutes to share your thoughts, and the floor is yours.
Thank you.
moderator, Ibu Dr. Diajeng Wulan Kristianti. First of all, I want to say it is very great honor for me to join with this prestigious international law conference. This is the second Bandung International Law Conference, and I want to greet first of all to my fellow Professor Ningrum. I'm very happy to meet you here because usually we can meet virtually. Maybe for 2 or 3 times we met virtually. And also I want to greet distinguished Professor Roy and Professor Irene Kalboli, and also Professor Huela Adolf, who also is here, and also my colleague from Gajah Mada University, Professor Marsudi Ratmojo. And good afternoon to Dean Dr. Idris, and also the participant of the conference who meet in person here at the auditorium of Tomiko and Mohtar Kusmaatmadja. This afternoon, I want to present my thought on law making in Indonesia, or maybe also in other country. So my presentation, the title of my presentation is to what extent law making process will make adaptation and transformation. But before I explain further, I want to argue that adaptation and transformation in relation to lawmaking should be carried out carefully, since it is the fundamental means for upholding the principle of the rule of law, democracy, and human rights. Moreover, a lawmaking process that produces qualified legislation become the most important sources of law in a country. So this is my main argument, maybe unlike the private law, because I'm the public law person. So I want to argue that transformation and adaptation should be carried out carefully from the perspective of public law. And COVID-19, the global pandemic that began in 2019, altered how we live in our lives. And there are a number of major problems due to COVID-19. First of all is the use of emergency powers. Almost every country in this world use their emergency powers. And the use emergency power then may lead to misuse of power. This is one of the biggest problem in terms of, or from the perspective of constitutional law. And the second is the problem of privacy, because the government conduct surveillance. I think that the privacy of the person are also in doubt whether our privacy carefully protected by the government or by the state. And then the third problem is compensation. And the fourth, and this is also very important from the perspective of constitutional law, that is continuing democracy, both democratic institution and procedure. So this is the four problems that mostly faced up by every country in the world during the COVID-19 era. And then how the state respond to this COVID-19. I think that every country made a different response how to handle the COVID in their country. Maybe some of us still remember how Germany, then New Zealand, South Korea, that actually at the time led by a women leader, that is German, for example, by the Chancellor of Angela Merkel, then South Korea as well, the president of the South Korea, maybe the female president, as well as the New Zealand, the female prime minister. Both or all countries carried out a different approaches that fit with the situation of their country. And but the government adopted a pandemic law in order to secure the life of the people using various forms. Some of the government used the scientific approach, such as in Germany. Also in other countries, because Angela Merkel, I think, she was a chemical engineer. So she is very appreciated to the use of the scientific approach. But how Indonesia? I think that at the early of pandemic, maybe the Indonesian government rarely use the scientific approach. Even January, I think January, we already had suspected of the coronavirus, but Indonesia still denied that the virus will not enter to Indonesia with some of reason. And one of the reason is that because the president didn't want to make a panic situation in this country. And personally, I a bit confused with the statement of the president. How the president can say that the pandemic or the coronavirus did not inform at the very early stage, because of the president didn't want to make the Indonesian people get panic. So, although it was considered that the pandemic creates lawmaking environment which allow the rapid process without scrutiny and the use of power without restraint. So this is the condition that we face at the very early period, at the very early era during the pandemic. For example, in Indonesia, at the time, Indonesia, the Indonesian government, both the House of Representatives and the President, issued the emergency legislation, what we call the peraturan pemerintah ganti undang-undang. So the government regulation in lieu of law. That is the Perpu number 1 of 2020 on state economic policy to handle coronavirus pandemic or coronavirus law. Now it becomes law number 2 of 2020. So at the time, there is a huge debate between declared the state emergency, in particular, or specifically the civil emergency. But 100 or more, I think that many people against that proposal. So the government finally did not make a declaration on the state emergency, especially the civil emergency, but it made a statement to declare the non-natural disaster or emergency. So the government did not use Article 12 of the 1945 Constitution, but rather the government used Article 22 of the 1945 Constitution. Both articles deals with the emergency situation, but use the different approach. So according to Article 12, the government should declare first the situation of the emergency in Indonesia. Whereas, according to Article 22, the president used its power to establish or to adopt or to introduce the peraturan pemerintah pengganti undang-undang without the need to declare firstly the state in emergency situation. So this law enact economic and finance policy adopted by the government to handle the COVID-19 crisis. And Article 27, paragraph 1, 2, and 3 deal with law enforcement. And all acts are not classified as states' financial laws and prohibition any act against government official through civil and criminal suit. And all implemented act and policy are not subject to administrative court review. So this is a number of the critique that raised by the public soon after the president issued Perpu number 1 of 2020. So this slide, I will explain about critics on Perpu number 1 of 2020, which now become law number 2 of 2020. First, it paves the way to the executive domination to tackle COVID-19 through Article 2022, not through Article 12. And these, which give broad powers to the president in relation to state budget using presidential regulation. So I mean here, through Article 12 of the Perpu, the president has a very huge power to make a change of a state budget, not using legislation, but using the presidential regulation, which to some extent, the public will ask about the inline or whether it against the Article 23 of 1945 Constitution. And the critics number 2 is that Article 27 of the Perpu limits competencies of the administrative court so that it seems to provide immunity to the public officer dealing with the use of state budget to handle COVID-19. So, according to Indonesian constitutional theory or dealing with the substance of legislation, the competency of the court in Indonesia should be regulated in legislation, not should be regulated in Perpu. And this is one of the weakness of we have of law number 12 of 2011, because according to the law number 12, the substance of Perpu has a similarity with the substance of legislation. So if competencies of the court should be regulated in legislation, not by Perpu according to the theory, but in practice, you know that Perpu can be used by the president to regulate the changes of the court competencies. Even though the Perpu that finally, if agreed by the DPR, then it becomes a legislation. But from the very beginning, the motive or the initiative to issue Perpu is a bit different with the initiative to introduce legislation. The introduction of Perpu is exclusively belong to the president. So this is one of the dangers in terms of the substance of Perpu in Indonesia. And critic number 3, Article 28 does not involve the DPR to make changes on state budget 2020. And this article gives power in changing state budget through presidential decree. And constitutionally, as I mentioned before, DPR has significant power dealing with it, dealing with a state budget. So this is the very controversial article that made by the president, I think, because the president issued the Perpu. And then number 4, the absence of clear meaning of stabilitas sistem keuangan untuk penanganan pandemi coronavirus disease or COVID-19 or dalam rangka menghadapi ancaman yang membahayakan perekonomian nasional atau stabilitas sistem keuangan. So there is no clear meaning of what is the meaning of the stability of finance system to deal with the coronavirus, or what is the clear meaning in order to address the threat that put the national economic in danger. So, and this resulted in no criteria that can be used to deal with whether the situation is already a danger. And this result in no criteria that can be used, as I said before, and there is a potential of high flexibility to determine the condition of financial instability that may lead to misuse of power. So this is the 4 fundamental critiques that raised by the Indonesian people or the civil society soon after the president issued Perpu number 1, 2020. Okay, the next slide, please. This is still the emergency, the states respond, use the emergency power, and it can face, or it can happen also in other countries. So they use the emergency power to tackle the coronavirus as soon as possible. And as a result, under such condition, a high level of adherence to democratic and rule of law principles, including human rights, common and fundamental values in most countries can be undermined. So I think that most countries in the world use or apply democratic and rule of law principle in managing the country. So during the pandemic of COVID-19, I think there are so many infringement to those principles. And this is, again, very dangerous in terms of the management of the country. Okay. Next slide, please. Moreover, another problem is that, the domination of the executive in decision-making during the emergency times is not surprising, using the argument of effectiveness and rapid response. So I think that in this situation, in particular in Indonesia, how the local government face the confusion how to deal with COVID-19, because the central government did not make a clear policy how to tackle that virus that spread throughout Indonesia. And the executive-dominated decision-making lead to rule by decree, operating in the form of discretion, which often to act above the law. So again, that this situation also happened in many countries, not only in Indonesia. However, other countries who can be classified as an established democratic countries that uphold the principle of the rule of law, the discretion can be controlled by the effective court. So we don't know whether the Indonesian court at the time can effectively control the use of discretion that issued by the government. Okay. Next slide. This is another problems I quote from Dr. Joel Grogan. She says that echoing the concern of many international organizations and NGO, the 2021 FIDEM report described the global trend toward democratic decline through increasing autocratization of state through the use of the pandemic threat by certain government to consolidate power within the executive. So this is still the problem that faced by many countries where the executive domination is very obvious. Okay. Next slide, please. Still, we say democratic problem. You can read from, this is a very famous book, How Democracy Died, written by Levitsky. So this is a very famous book in relation to democracy. In this book, the writers say that since the end of Cold War, most democratic breakdown have been caused not by general and soldier, or in other words, not have been caused by military, but by elected government themselves. And democratic backsliding today begins at the ballot box. So this is the situation that currently also happen in other countries, not only in Indonesia. The democratic problem, democratic backsliding, and that can put people or civil society in dangers. There are so many infringement in terms of, for instance, the academic freedom, then freedom of the speech, and etc. And at the early pandemic COVID in Indonesia, I think the police issued like a telegram that can used how to handle critic to policy that issued by the government. You can imagine that the legal basis is not use legal law, but use like a telegram. So according to the Indonesian legal system, even telegram cannot be classified as a rule or legislation. Okay, the next. Where are we now? I think we are in the transition phase from pandemic to endemic. Even though the government does not, up until now, make a very clear statement that we are in the transition phase from pandemic to endemic, and we come to the new normal life. In this situation, I think that it is very important to make a balancing between technocracy and political judgment. The involvement of medical scientific experts work within the executive branch, and they play a leading role in helping set up lockdown measure adopted by the government, advising on the timing of relaxation and tightening. And is this the example of transformation? from the anti-scientism in the early of coronavirus detected in Indonesia. So maybe this is one of the example of transformation in Indonesia. At the time or at the very beginning of the COVID-19 era, an epidemiologist from the University of Indonesia, Dr. Pandu Riono, stated, since January 2020, we have been expecting suspected corona cases in Indonesia and are also upset how come the case report continue to be negative, and denial position of the government was also unusually high. So I think we lost 2 months, almost 2 months, dealing with coronavirus. So in March 2020, the president make a report that yes, there is a suspected of coronavirus. In practice, the scientists predict that since January 2020, there is a coronavirus suspected in Indonesia. So I think 2 months is 2 months was very important how to make a policy in dealing with the coronavirus. Okay, next slide, please. And this is a very critical phase. So the transition phase is very critical. It is important to make transition plan toward COVID-19 resilience. And I use Singapore as an example. According to the government of Singapore, they introduced 4 stages toward the resilience of COVID-19. The first one is the preparatory stage, important adjustment to health protocols, rules on social activities and travel, etc. And then transition stage A, surveilling, testing still in force. But the government did not make a detailed explanation about what is the transition stage B and COVID-19 resilient nation. So this is the 4 stages. They plan the 4 stages to deal with COVID-19 toward the COVID-19 resilient nation. Up until now, maybe I was wrong, up until now, we didn't hear, we haven't heard about the plan of the government, how to deal with the resilience of COVID-19. And it is very important for us because we are the holder, the holder of the power, the highest power holders in this country. So we have to know about the current situation, and we have to know about what is the plan of the government, the very clear planning that made by the government, and we have the right to know. Okay. Next slide, please. Okay. So what next? Lawmaking is still fundamental to provide solid legal basis toward resilient nation, both in terms of procedure and substance. And prioritizing post-pandemic law and governance innovation for just, peaceful, and inclusive society. So I think that in the future, the government should make a priority which law that can be made before other law. So the priority of law making, both in procedure and substance. And the post-pandemic law and governance innovation should be just, peaceful, and inclusive society. So this is the nature of the post-pandemic law and government innovation. In Indonesian context, it is important to assess the existing legal policy, which seem to emphasize on economic matter. So I think during the last 2 years, we witnessed about the new legislation that introduced or promulgated by the government. And most legislation deal with the economic matters. We still remember about the job law on creation, which used the omnibus method. And I don't think so that omnibus method then can be used regularly in terms of law making, and it can be called as adaptation or transformation. Adaptation and transformation cannot infringe the underpinning principles of Indonesian lawmaking, such as the principle of meaningful participation. This is in terms of procedure, and the Constitutional Court has made a decision that include the meaningful participation that consists of the right to be heard, the right to be considered, and finally the right to be explained should be carried out in order to make a meaningful participation in terms of law making or legislation making. Okay.
Professor Susi, sorry to interrupt. I
Yep.
think you're running out of time, so I will appreciate if you just go to your conclusions.
Okay.
Thank
The
you.
next slide is conclusion. So still what next? Now, this is the value of the rule of law, human rights, and democracy should be carried out in the next period. Okay. Next slide. Democratic accountability. It means the effective control over COVID-19 measure by Parliament, and then legal accountability, compliance on the rule of law, which need the effective court, and intra-executive accountability and transparency. So these three, I think these three matters should be considered by the government in the future. Okay. This is the concluding remarks. I again want to quote Clement Fatovic and Benjamin Kleinerman from the book Extra Legal Power and Emergency. So perhaps even more troubling than the violation of the law in times of emergency may be the impulse to legalize any measure that the government claims necessary to deal with an emergency. This is important to be considered by us because a number of emergency law that produced during the pandemic era still in force. And then this is the final concluding remarks. Again, I quote the Cicero. Yes, next please. Salus populi as suprema lex. The safety of the people is the supreme law. So whatever transition, whatever adaptation that could be made by the government, the safety of the people is the supreme law. Thank you very much for all your attention. I'm apologize for the quite long presentation. Thank you. Still mute.
Oh, sorry. Sorry. I still mute myself. Sorry. Thank you so much, Professor Susi, for the very interesting presentations. I do really agree with your first highlighted statement that is very important, that adaptation and transformations is, if it has to be done by the government, we should do it very carefully. And you also highlighted that the the use of emergency law by the governments that is also sometimes may lead to the misuse of the power. And you also give some critics to the existing law number 2 to 2020 on how the government handled the COVID-19. And you also give some solutions to the problems by giving some concrete measures, but what next that the government should respond with regards to this COVID-19 pandemic. And I also have the same positions with you. We really look forward for the planning of the government in the future on how they will solve and how they will deal with this endemic in the future. Thank you so much, Professor. And now we move on to our fourth panelist. We have also distinguished panelist, Professor in Law at the Faculty of Law, Universitas Sumatera Utara, Professor Ningrum Natasha. Professor Ningrum Natasha is the professor of law in University in Universitas Sumatera Utara. She's also specializes in competition law. Yeah, so because I've learned from your current publications, you produce or you publish numerous articles with regard to the competition law, and I also have a little bit time to learn your presentations, Professor, and you address a very interesting issue with regard to how this post-pandemic situation affect the globalizations. You also introduce a very interesting terminology theory, co-opetition strategy, the combinations between cooperation and competitions, and how this theory can provide the solutions to this issue resulted by this COVID-19 pandemic. So without further ado, Professor, I will give you 20 minutes to share your thoughts. And for Professor Ningrum Natasha, the floor is yours.
Thank you very much for inviting me here. I was honored, to see that I was putting as invited speaker. So, USU and UNPAD has a very long relations, very nice relations. So this is good to know that you're running this conference, and I thank the Dean and Professor Susi, old friend, and Professor Huala Adolf also. This is a very critical time. In my class time, 3 o'clock, I usually allow them to not fall into sleep, but I allow them to have their Starbucks or whatever in a class. So let's room with me in the middle of this very hectic time. Wake up so we can learn something. My background is on competition and international law. It was, very astonishing to me that from the first speaker, the second speaker, and even you talk about something that is not emulates, but it's intriguing, even from each perspective of, of every division of the law. You, Professor Susi, have a strong background of constitutional law. It's good for me to learn, to study that. You also have, you feel intrigued to see what's going on. So as a moderator warned us, it's very good that I will take you roaming, swimming through, Googling through what I call competition. Yeah. I study, I learn, I did my postdoc everywhere in the school of thoughts where competition is very important, it's very strong. And we have the law, we enforce the law almost 22 years, 400 something, close to 400 decisions. We're a benchmarking state among Asian countries. But when it comes to pandemic, everybody will, shut their comments and come back to their origins and learn how to deal with that. So every time people criticizing what Indonesia does, I stand up and said, do not say anything about Indonesia because it's not easy. It's not easy to regulate or to, let's say, to take care of 260 million. You see, so I said there's no one system fits all. Yeah? You cannot say that this is how we do it. We can learn from other countries, but definitely Indonesia has its strong own way. Can you do this? Oh, okay. Before I take you to the world, I like to speak, so you have to remind me of my time. I keep thinking about what happened to the globalization. I now heading a PhD in law program. So one of the subjects still globalization and blah, blah. And I said, that's the very ancient word, but this post-pandemic makes me think, does it affect us on the globalization movement, or does it make each state become more selfish? Or deglobalize, don't care about others, but think about what happened to us. Or are we simply forced to deglobalize, or do we adapt to new changes? So your issues really in line with what I've been thinking, but you come from a constitutional law part. Next, please. I'll just tell you to do that. Don't forget that we now come also to think about regionalism in what are we facing. ASEAN is very strong example of when you face a pandemic, we refer to what the WHO or World Health Organization said. Every statement that they said, we quote and we adapted. All right? But when it comes to the execution or implementation, don't you think that these are a group of states becoming more selfish by, we refer to ASEAN said, does the pandemic will spread among ASEAN, and how do we respond to it? EU and other countries also deals the same things. Next. So my first issue that I want to raise is, does pandemic affect globalization? So let's room first through what globalization drives. Do you believe that it's shrinking because in advance of transportation technology? I'm not going to go through each point, but you can see it drives us to what? We become dependent to other states. Barriers among countries are tumbling through, you name it, and national economies are merging and create an interdependent economic system. So we get strongly connected through internet. And the interdependence of globalization, you can see the result of, this is funny, actually, funny joke, because of the interdependence. Do you ever realize why the instant noodle, where they announce it's becoming more expensive, it kills most of Indonesian students? Why? We live and eat instant noodle, alias Indomie, right? And we're protesting, why are you raising the price? Do you know exactly that the fact tell you the country's running out of wheat because of Russian war? We don't grow wheat here. So it's so far, but it's so immediate affected to us. Cost of living crisis, due increase, car industry running out of chips due of COVID. I have something broken and they told me, you have to wait 6 months because the Chinese manufacturer are closed. Why? Why do we have to depend on them? Why? And they told me because it's pandemic. Don't you know that? So you don't know until it hits you. Remember what I said that, literally, I don't care. But when it comes to, so there is a real pandemic. World economic affected by this is also a strange story. It's the ship stuck in the Suez Canal and it stopped the entire economic movement. Okay, next. Next, please. So who pros on globalization? It's broaden access, lift people out of poverty, you name it. Culture awareness. Hey, Indonesian kids like you, students like you are more aware of Korean culture than us with the Beatles in our age, right, Prof. Susie? Yeah, in our age is the Beatles. But look at this. The globalization is a word of definition spread all over the world without ensuring its effect and becoming common understanding among states. So if you don't go global, you are orang kampung. You should go global. You should go bergaul or, connected to other states. But after the pandemic, the globalization should be questioned. Now you go to the cons. Can you go? Okay. Do you think people almost all over the world pros to globalization? Not really. We should realize This is Professor Susie's field. Government has reduced autonomy to develop and implement local legislation, right? We should go to the convention. We should comply with this. Otherwise, we go village states. Why don't you comply? It's an international standard. You know, we almost forgotten that locals, regions also have its independency to pass the law. So national government less able to protect national resources and its domestic workers. Cross-border crimes increase. This is the cons against globalization. Access to international institutions developing laws and supporting law enforcement are also affected. And again, globalization remain on the discussion whether we maintain the purpose or we turn back to regionalism. I don't know, maybe one day ASEAN will be coming stronger and we adopt it like EU. Don't laugh, Professor Huala, we probably already tired if it's happened, but who knows? Nobody can predict that. EU did that, through several struggles, complaints, discussions, debate, and look at them now, right? Okay, can you go on first, next, please? So I put this paragraph to challenge you whether it is perfect that we keep doing it now or deglobalize. Do we close our borders? Hong Kong just recently lifted up the, you put on quarantine. For so many years, almost 2 years, they quarantine people 2 weeks. Like crazy. People love to go to Hong Kong, for business and for traveling. Last week, they just recently lifted up. So closing the border, restricting immigration, restricting export, import. Anything can go with global or deglobalize. So I put nothing changed if nothing changed. I don't know. We should respond to it. We should think about it and what's going to happen in the future. Next. Now let me take you to my core of my presentation. I'm a competition people. So rethinking the law in the post-pandemic. What is that? Actually, one book triggered me just now when Professor Huala and I talk in that other room. I asked my PhD students to read the legal transplant book written by Alan Watson. He's so amazing because he said, you don't have to go through war, you don't have to go interdependency among states, but now countries are transplanting any state's law to the country. For example, it's the law that I studied, anti-monopoly, or the US call it antitrust. Nobody knows, nobody exactly predict what happened. We just adopted arbitration, consumer protection, money laundering. They're all new. And it's been transplanting in each country legal system. It may grow or it may die. In Chile, they did a research. It's even grows stronger than its origins. So, and people read the book and say, "Oh yes, but nobody exactly have the view that when pandemic comes, what is going to happen with all this law? You're not instructing to transplant anymore because your interdependency. My research tell me that you have to think, sit down, think. Professor Susie explained just now that there are some certain standardization that you cannot go, right? You cannot go against it because that's what your school of thoughts teach you. There's something that you cannot go against even pandemic hits you. Well, we question the impact of the presidential decree. The minute the government say it's force majeure, it's amazing that it affects anything that can run in this country. But don't worry, don't be ashamed. A lot of countries also do the same. For example, Singapore on April 1st issued a bill related to COVID-19, a policy of exemption from liability for the inability to carry out contractual obligations. Who wants to go out and implement and execute the contract? You call it what you call it? Do you call it non-performance, default? And I can sue you because you're preventing go out and do the contractual obligation. So the clause force majeure helped us a lot. As a person with a competition law background, what is important to me to learn that, something on presidential decree number 12 and number 13 actually. Pandemic is not considered as a non-natural disaster. This is important as a reference. So the government just swept it off and saying, we issue this decree and it falls under force majeure. If pandemic is not included, shh, be quiet, it's included in there. So if you go through a real regulation, do you call this government discretion? But I close my eyes and I keep going on. Remember, there's no clause on non-natural natural disasters on that law, on Presidential Decree number 12, 2020. Can you go on, please? Okay, what happened with competition? The school of thoughts I studied everywhere in the whole world saying that competition is good, it provide consumer welfare, the winner takes all, and it's just good for the welfare. Okay, I'm not going to go against this because this is it's not even a standard. It's the thought that they put on your brain when you learn competition law, antitrust. Okay, OECD stated something, the World Bank stated something, our law stated something, but can you go on? Next slide, please. But listen, the first thing that hits people like us is during the pandemic, because of the Peraturan Presiden, Perpres number 12, it's actually put a new approach, relaxation. Relax, you do not to compete. Why? The world has been hit by pandemic. So it's an excuse. Look at that. The entire APBN state budget, region budget are switched to prevent us or to cure us from pandemic. And with that, do they go through a certain meetings to ensure everybody knows about it? No, Ibu. They just said it's the discretion, the expenditure must be focused on health and everything goes with that. So how pandemic affected the law? Do we adapt? Do we agree with that? Does it affect us? Do we still embrace? I gather a lot of questions. But since my field is competition, can you go on, please? Hello? Yeah? Okay. I need to learn something from outside the world. Is Indonesia playing on its own? Not really. The OECD, the UNTAC, they put the map and say, on competition law enforcement, we adopted what the World Health Organization said, and we should embed it in what our law says. You know, so they put relaxation. They say you can choose whatever manufacturer or whoever can serve it first without competition. Remember, without competition, and you can appoint directly. Why? Because it's force majeure, and not Indonesia, but the whole world hits by that. So look at all the examples. The European Commission responded, the ASEAN responded, even Germany, which is very famous for its anti-cartel law, saying, okay, it's okay. We will close our eyes and we will allow you to do a direct appointment just to fasten, to shorten the process so everybody can get, what we need for. So relaxation is very, very famous word for people from competition law. Next, please. Next. But remember, I have one session with KPK, Corruption Eradication Commission one day. You know, I said, do you put your eyes on this? Oh, yeah, but our intelligence is working on this. Can people just go and appoint? Indonesia is just a gigantic country. Can you observe each APBN, APBD? They smile. And you know what happened? Menteri Sosial get caught. Yeah, Menteri Sosial. So actually, he's a friend of mine. I know him very well. Yeah. I was surprised that why? Nobody wants to outside because so fear of the pandemic. So they make a fictitious supply and they rob the state money, the state budget. And people like us been protested, been asked, why you introduce relaxation? But I said, it doesn't relax. It doesn't mean that it means that it is relaxed through the omission of criminal acts of corruption. So I think later on you will find out and we'll have some cases. Next, please. Next. Okay, look at the Indonesian economic system. Yeah. 4 times amendment of constitutional law, 4 times. Not even once dare to touch Article 33. Not even once. But at the 4th amendment, they introduced the word competition. So now we suddenly think that it's been constitutionalized. Good, but it's too late. Our country has been very, very, I said, radical. People are not agree with my terms, but we have been very liberalized. You know, we compete with everything that we can. You probably even don't remember the origins names of the banks. May Bank BEE, oh, it's originally Bank BEE, but you call it HSBC, you call it any foreign banks. So free trade. Do I say that we are hypocrites sometimes? I rather feel that we are hypocrites. We say our economy is built with togetherness and familiarity and gotong royong and kekeluargaan, any word that you want to call it. However, we introduce very harsh competition in our daily economics execution. So when some of us sit together and try to discuss what has been so named as co-opetition, I thought it comes from us. No, it's not. Actually, so there's some people who have different school of thoughts, very radical on competition or collaboration or cooperation, pure cooperation. But Brandenburger and Neil Buff introduced what's so-called co-opetition. That is not surprising to some people, but surprise for us because during pandemic, that's the one that has been introduced. You don't need to compete harshly. Why? Maybe co-opetition is a new definition that we should embrace and make it as one of a choice on how to run economy. Next, please. What is the competition? Okay, now it's been discussed in a lot of academic literatures. It's actually the combination of cooperation and competition. It's the choice of how we do it. If you talk about competition, definitely, what's our vaccine name? Sinovac should be compete with who? Pfizer with Moderna. If you don't talk about competition, people we watch it. I watch it. I said, whoever get it first is going to be the richest manufacturer or country. But if you go to those manufacturers, you see their face. You portray thousands of people dying. Do you think they want to make money out of a dead bodies because we don't know how to cure it? No, you should do co-opetition. You can compete in sometimes, but now we need cooperation. So you see, actually, competition has been embedded and executed. A consortium of all of this has been working on it. Next, please. Now, do you want to embrace it or not? This is something that I call adaptation. The school of thought from the West, where I go and study, we don't know this subject. So I should go to a place where they invented it, studied. My professors, my guru always told me, pure competition is individualism, independence, and divergent goals. While Ningrum, your country is pure cooperation. You work together, collectivism, interdependence, and convergence. So if co-opetition now is actually try to be introduced and try to be embraced, try to be adapted, we actually not the first one who think about it, not even Brandenburg, but our Indonesian economists like Pak Swasono already introduced it. Some cendekiawan or some great thinker economists from ICMI also, Dawam Raharjo. I love to read all their articles. They said Indonesia should not be shame or, timid or reluctant to adopt this competition. Except the question is when. So competition-driven strategy helps to develop a sustainable business. Do you believe it? So the 3 school of thoughts now are on the table and ready to discuss. Next, I nearly finished. So why you should cooperate with competition? Okay. Another best example is partnership, is kemitraan that we know now. Right? You say, okay, kemitraan, oh, I wish I do not cooperate with you, but you can't run away. It's the government strategy to help you, to keep reminding you should help each other. So it's also one best example of cooperation. Next. I apologize if it's too little for you, too tiny for you to look. But look at how German, US FTC, the French, Australian deals with the regulatory, the procedures, the mergers, the state aid. What is state aid for us? Bansos. They also deals with that. So don't be ashamed. We're in the middle of these horrendous changes of the world. And each state has its own way to determine whether we are going to follow pure competition, pure cooperation, or apply cooptation. Next, please. Nearly finished. What about our Indonesia? Don't worry, we are the country who adapt easily and rapidly. They expose this. Oh, now we accept you can do cases through internet, through online. They call it electronic, whatever. So it's also change. So change is inevitable progression, and progression is a choice. Next. 2 questions that I posed. Is it the time for Indonesia to implement it? Do you think that this concept is ours? Okay, so I'm not surprised when other experts explaining about now we have a co-optation. But my concern is Indonesia does not really or able to determine whether it's co-optation under Indonesian perspective, because we know ekonomi Pancasila, ekonomi kekeluargaan. Is that what you mean with co-optation? If it's yes, let's have a strong policy on that, and let's study it. Let's us share it. Let's all of us study it, and we can stand up and tell people that we easily adapt, not transform, because it's not new. Adapt to new changes. Next, is it a time for Indonesia? So the question goes to the business actors and goes to its value, and of course, how do we observe this development? Will it be possible? I'm not the one who is able to answer it, but according to my observation and my research, I don't think we need to discuss it. I think it's one of the best examples that Indonesia posted during the pandemic. The relaxation as well as law enforcement coming in the same time. So it's not people are opportunistic to use it because it's a relaxation. My final slides. I hope my time is still okay. This conclusion. The co-optation concept is the best example of rethinking the law in the post-pandemic. We're now go back to square zero and are able to choose. Are we adapting to new changes or are we transforming? Before I explain or I mention something about Alan Watson's book, are we choosing to be asked to transplant other countries' law? Well, now we are on the same corner, same flow. So we have more liberty to choose whether we adapt it or we transform. The co-optation is a phenomenon, is a collaboration among all competitors. It's not actually developed in the last few years. However, pandemic is the best mechanism to trigger that. Now you don't discuss it behind the door. You have to think and you have to adapt or transform is our choice. And pandemic not only forcing the countries to rethink, to adapt or transform, but we should be able to make a decision where we are now. So the conclusion is there's no one system fits all. We should be able to sit up together, stand up and sit down together with other countries because we were hit with the same thing. Even big countries are collapsing. And Indonesia is not also the best example. Even President Jokowi keep stating that, okay, we're in the safe zone. Like yesterday, Menteri Keuangan Sri Mulyani stated, kita surplus 100 sekian, something 100 trillion. Come on. Yeah, stop all of this nonsense. So because there's no one system fits all, the world need to accept changes I think my choice is adapting to the new approach. With that, I conclude my presentation. Thank you. And we should be ready to discuss. Thank you.
Thank you. Thank you so much, Professor Ningrum, for your very interesting, but also inspiring presentations. Yeah, you discuss a lot about the pandemic effect to the globalizations, or rather is forced us to the globalizations. You also introduced the concept of the cooptations, whether we should embrace, Indonesian system should embrace with that concept or no, whether we're ready or no, about the business factors. You also come in the very interesting conclusions that cooptation actually the best examples, yeah, of rethinking the law in the post-pandemic world between adaptation and transformation. And also you highlight a very important conclusions that because of this pandemic is a moment, yeah, for forcing us to rethink, not just to rethink, but also to quickly adapt and transform to the new change, either by force or voluntarily. So thank you so much, Professor. And then last but not least, we have also another distinguished panelist that also will share his thought with us. But before I give the floor to the last panelist, I just want to remind the audience that in the coming 20 minutes, we're going to have a question and answer sessions. So for the audience, please get your questions ready. Okay, for the last but not least panelist, we have Professor Marsudi Triatmojo. So Professor Marsudi Triatmojo is the professor of law in the Universitas Gadjah Mada. Okay, so the professors, Marsudi specialized mostly in the field of the environmental law and the law of the sea. He's also a professor in international law because his current publications mainly regarding those fields. And Professor Marsudi Triatmojo, according to his presentations, I have a chance to have a look. Professor, we're going to discuss about the reflections on legal educations in the aftermath of the pandemic, because especially in his faculty of law, Universitas Gadjah Mada. So professors, we will look forward to having your thought with regard to this issue. Please briefly share your thought about this in the coming 20 minutes. So from the professors, the screen is yours.
Oke, terima kasih. Thank you to Ibu Dr. Diajeng Wulan Kristianti, who has introduced me to the audience. And good afternoon, ladies and gentlemen. Thank you for inviting me in this prestigious forum. Thank you to all the committee of the second Bandung International Conference on Law. And in particular, I express my appreciation to Dr. Idris, Dean, Faculty of Law, and Professor Rina Indiastuti, Rector of Universitas Padjadjaran, who have made this forum possible. As the last speaker of this first plenary sessions, I would like also to extend my regards and gratitude to the previous speakers, Professor Roy Partain, Professor Irina Kalboli, Professor Susi Dwi Haryanti, and Professor Ningrum Sirait. I'm lucky actually because I speak after Professor Ningrum, who has made this forum live. Yeah, she was very enthusiastic, and of course, I believe that all audience right now is already wake up. Yeah, without coffee. Okay, how are you, Professor Ningrum and Professor Susi? I'm sorry I cannot come in person, yeah, because I have some activities here. So I joined with this Zoom. Okay, now allow me to share my presentations entitled Reflection of the Faculty of Law, Universitas Gadjah Mada in the Aftermath of Pandemic. I choose this topic because as a former dean, I really concerned about the legal educations, yeah, after the pandemic. So what has happened? And this Actually, this presentation is about my experience in my faculty related to the implementations of lectures during and after the pandemic. It was inspired by Professor Casey articles entitled Reflections on Legal Education in the Aftermath of Pandemic. Beside this article being very timely with the current situations, I was interested by what he said, that online programs will expand based on the largely successful experiment in delivering legal education online during the pandemic. But this expansion must be thoughtful and deliberate. He said, based on this statement, we must really pay attention to the learning process of legal education. We should not immediately apply online learning without paying attention to the type of subject we teach. In my communication with the committee for decisions, I will present the topic of law teachings. For that, I will present the following points: background, and then practice at the Faculty of Law, UGM, and then legal education after the pandemic, and conclusions. Yeah, I hope I will manage my presentation less than 20 minutes. Okay, next. As a background of these presentations, just to remind us all about the COVID-19 pandemic in Indonesia. Here are the stages and policies related to education in general. First, in December 2019, WHO announced the discovery of cases of pneumonia in Wuhan, China. And then second, the first COVID-19 was found in Depok, West Java, in March 2020. And then third, on March 11, 2020, WHO declared that COVID-19 as a pandemic. And fourth, in responding the COVID-19 pandemic in April 2020, governments made several policies. That is already explained quite comprehensively by Professor Susi, including the controversies of the policies. The policies including large-scale social restrictions or pembatasan sosial berskala besar (PSBB), and then the establishment of the COVID-19 Task Force and National Economic Recovery, and requiring all Indonesians to implement health protocols such as always washing hands, wearing masks, and keeping a distance from each other. And then fifth, since January 2021 until now, the government has implemented a policy of enforcement of restrictions on community activities, pemberlakuan pembatasan kegiatan masyarakat or PKKM. Well, it is understandable that the COVID-19 virus has changed all educational arrangements in various countries, including Indonesia, which in this way given a new face to Indonesian education. In the beginning of the pandemic, there had been a general policy that teaching and learning activities were carried out online. Next. The Faculty of Law and other faculties at Universitas Gadjah Mada, like other educational institutions, I believe, canceled almost all physical activities on campus, restricted the use of other facilities on campus, and moved almost all classes online. The faculty conducted most classes and activities virtually or in a hybrid online and in-person format. Despite the effort of administrators and lecturers, many students express frustrations and disappointment that their school year fell short of a full law school experience. Next, in conducting lectures during the COVID-19 pandemic, lecturers and students as well as administrators of the faculty face various obstacles. These obstacles, both personal and professional, range from physical health to financial strain and technological competence. Next, and for myself and probably most of lecturers, online learning has an impact on increasing my capacity as a lecturer. I have never used a digital meeting media to teach before. And the pandemic forced me to adapt and quickly learn to be active in using online meeting media, such as Zoom and Google Meet, uploading assignments in Google Classrooms and e-learning, as well as using social media to fulfill assignments. I feel that the online meeting application available is useful in the learning process during pandemic situations. Next, the difficulties I face in conducting online learning are in monitoring participants. Network problems often makes it difficult for some students to enter and join online classes. I also found that there were students who did not actually attend lectures. The student entered the meeting session, but while the lecture was in progress, he actually did other activities. With the excuse of having problem with the video, the student then did not show himself and could only hear his voice. As a result, the actual activities they do during lecture sessions are difficult to monitor. I once tested this by calling the names of students who seems not actively discussing during online lectures. The student didn't answer. He only answered a few moments after I called. When I asked about the last thing discussed in the lecture, he couldn't answer at all. And then the student later admitted that he did not listen to the lecture sessions and instead did other things. Okay, next. Now that the COVID-19 pandemic is more under control, starting last month or in this year academic year, we have started running lectures in combination between face-to-face 70% and online 30%. However, to reduce health risk, we also implement safety measures such as mandatory vaccination, frequent coronavirus test, and social distancing. The distribution of lectures, 70% face-to-face and 30% online, is purely for health reasons, and even may change back to 100% online if the COVID-19 pandemic worsens. This policy is designed based on assumption that many people think that when the COVID-19 pandemic has been brought under control and only fewer people are exposed to the coronavirus, we will return to normal life. With this in mind, lectures will also return to the way they were before. Next, actually, we could take advantage of the learning experience during the pandemic. Even though there are weaknesses, we should still be able to take advantage of online learning. The advantages of online lectures include online learning activities can be accessed anywhere and anytime. Learning can be done flexibly. We can do it side by side with other activities. The implementation costs are cheaper. There is no need to incur more costs such as transportations, maintenance, and other learning infrastructure. Therefore, the policy of 70% face-to-face and 30% online lectures must be seen as a general guideline for conducting lectures according to the need of each lecturer. Next, previously, online learning was only carried out by a few lecturers who were able and mastered online learning technology. Now, every lecturer can do online learning. Most people, especially students, are also familiar and used to taking online lectures. Considering these situations, we can change the law school curriculum, especially the pedagogic patterns. For learning patterns, we can sort out which courses are appropriate to use online learning and which ones must use face-to-face. The determinations is based on the substance of the subject in questions, whether the course emphasizes on knowledge, skills, or values. We know that every subject contains all these three components, but each subject has an emphasis on each component. Next, I agree with Professor Casey that the determinations of which courses or topic are best suited to online delivery will not be an easy task. It will likely entail a wholesale review of the law school curriculum and will require a deep dive into the knowledge, skills, and values that a program of legal education should deliver to law students. Next, apart from the guidelines for conducting lectures, 70% face-to-face and 30% online, we have not discussed the curriculum comprehensively regarding the post-pandemic situations. In fact, the curriculum we are currently using is a new curriculum, which was adopted last year and is formulated based on the principle of outcome-based education and accommodated the government program on independent learning, campus independent, or MBKM. Based on this 2021 curriculum, students studying at UGM is required to take and pass 51 courses with a credit weight of 146 credits. As I mentioned earlier, of course, all courses contain aspects of knowledge, skills, and values. However, if we look closely, most of these courses are doctrinal courses with an emphasis on knowledge, approximately 38 courses. Then there are 10 courses that emphasize on skills, and there are 3 courses that emphasize on values. Next, and the new normal for law educations. In the aspect of knowledge courses, online learning may be more appropriate to be used for doctrinal courses that contain knowledge on the basics of laws, and lecturers could deliver their courses mostly via online meeting media, such as Zoom, Google Meet, or others. And they could also upload assignments in Google Classroom and e-learning, as well as using social media to fulfill assignments. Of course, they can still meet face-to-face when some part of the course topic require direct explanations. And then, in other hands, courses that emphasize on skills need to be conducted face-to-face, especially legal skills educations and training or pendidikan dan latihan keterampilan hukum courses. The PLKH courses require interpersonal relationships, which may be more difficult to view, understand, interpret, and manage in an online environment. These courses contain topics on various competencies for lawyers, such as counseling, negotiation, simulation, base problem solving, and etc. In these courses, students should be trained for deep critical thinking and strategic planning. This type of courses often rely on mentor relationship, include observations of lawyers in practice, and benefit from reflections on professional experiences. And finally, there are three courses, namely religion, Pancasila, and citizenship, which contain values that should be taught face-to-face. These courses focus on basic ideology and norms that can be used as foundations for legal ethics, the legal professions, and the development of professional identity. Next, as conclusions for law teaching in the aftermath of pandemic must be designed seriously so that its implementations can achieve the target as expected. And new normal actually it's not normal. When the pandemic situation has started under control, most people assume that the situation has returned to normal as before. This should not be the case because new normal is a current situation or social custom and etc. that is different from what has been experienced or done before, but is expected to become usual or typical. Therefore, law teaching must be held based on current conditions by utilizing experience during a pandemic, including online learning experiences. And the use of online learning methods in legal education is inevitable. Currently and in the future, online learning has become a part and a choice for lecturers and students. The technology and infrastructure for its use have also grown and more sophisticated and cheaper. Therefore, law school need to make the best of it. But the determination is based on the substance of the subject in questions, whether the course emphasizes on knowledge, skills, or values. I think that's my presentation I can give. And once again, I thank you for the opportunity given to exchange these ideas. Thank you.
Thank you so much, Professor Marsudi, for the very interesting presentations. So you discuss in detail about the problems and challenges faced by the legal educations during these pandemic situations. And you also discussed further with regard to how your faculty deal with these situations. And also in your conclusion, you said that this is a new normal, is still not the same it's not still not normal. And then the online teaching becomes inevitable method of teaching in these new normal situations. Thank you so much, Professor. Okay, now we come to the question and answer sessions. And due to the limitations of time, I know I have to apologize that according to the schedule that we should stop these panel sessions at the 3:30, 3:30. And I'm so sorry for exceeding the time because we just finished the presentation from all the panelists and I have to limit the questions, 3 questions due to the limitations of times. And in the chat box now, actually we have the first questions addressed to Professor Roy, but unfortunately Professor Roy has to leave the room due to another meeting. So for the first questions that addressed to Professor Roy, the committee, we will send it by email to Professor Roy, and hopefully the Professor Roy can answer it in writing. So then the participants here is Madayuti Pertiwi can have the answer by email from Professor Roy. So sorry for that. So now I will go straight to the second question in the chat box. This question addressed to Professor Ningrum. And the question is, what is the limitations for competitions and innovations, since both of them in competition law become paradox, especially for post-pandemic? So Professor, please answer briefly the questions. Thank you.
Well, it's phenomenal because usually intellectual property rights has been exempted by the law. So even if people on the normal situation, when they learn, when they study competition, is always to opposite or to how do you call it, a paradox. Now the post-pandemic is, if you approach it in the name of competition, definitely there is a certain regulation which protected intellectual property right. It's an incentive for people to invent something. So they allow you to monopolize, to keep it for several years, to enjoy your invention. But if I take it back, if at that time we do not cooperate with all states or all countries in the world, you can imagine if one country invented the vaccine first, that can be the richest country in the world, in the name of competition, because that's the incentive for them, because they found it, or they not invented it, but they I think it's just the lucky opportunity, because at that time, every country are racing to do that. So post-pandemic, I don't know. I kind of, not confused, but I think post-pandemic, we should talk about more humanity above competition. Humanity above competition. Incentive is to cooperate, not to sell your invention in the name of competitions. That's how I feel post-pandemic. Before, let me tell you the truth, I study everywhere. They keep telling me that competition is above anything else. So now maybe not myself, but everybody should look at it carefully and think about the adaptation to approach of competition. Thank you.
Thank you so much, Professor. So I hope it answers your concerns, Pak Yayan Hernanto. Thank you so much for the questions. And then for the next questions from Madayuti Pertiwi from Unpad, you also addressed these questions to Professor Ningrum. And she said that I'm very interested in the words in your final conclusions. There's no one system fits all, and the world needs to accept changes by adapting the new approach. So what are the urgent things to make changes to Law number 5 of 1919 in order to adjust to the times and the economic recovery of the Indonesian state after COVID-19 pandemic? I hope the question is clear. So, Professor, please.
Okay. I think I did mention about the relaxation promotes by Indonesian Competition Commission, or KPPU. Relaxation, it means, for example, they do not enforce the merger regulation strictly during pandemic. So mind you that there are several companies pass that process without examining whether it harms competition. That's one thing. So relaxation. The second one, if you want to change the law, you know how horrendous it is. If you need to go to the government or DPR, I don't like my students if they write to me, Professor Susi, in my thesis, I suggest amendment to the law. Do these people know that it's very politically heavily involved, and it's not easy. So I don't suggest changing the law, but changing the way they approach through a lower regulation that can be implemented. That should be more possible than suggesting to change the law. That will be my response. Thank you.
Thank you so much, Professor. So your approach is more changing the implementation law rather than changing the law itself. Yeah. Thank you so much. And then our last questions, unfortunately, and the question from Joshua Hari. You asked about the role of the law in reshaping legal system after the COVID-19 pandemic. How renewable energy could contribute in the future compared to the fossil fuels, especially about the impact and the risk about the climate change issue or intergenerational equity. If I'm not mistaken, in your presentation, Professor Ningrum, you addressed a very little issue about the fossil fuel, so you could probably respond to these questions, or maybe from Professor Marsudi, because if I'm not mistaken, your field of specialization also in environmental law. So if you want to add something or respond to this question, please feel free.
Ibu Moderator, I rather Professor Marsudi or Professor Susi also respond. So we share all the burden.
Okay, thank you, Professor Ningrum. So probably
I can answer it, but I rather hearing also my colleagues' response to it.
Okay.
Right.
Okay, thank you. So probably Professor Susi, you want to respond to the questions, and afterward Professor Marsudi probably would like to also respond. Please.
Can you repeat the question, please?
Okay, so the question is about the role of law in reshaping the legal system after COVID-19 pandemic. So more specifically, Joshua asked about the renewable energy, how the renewable energy could contribute to the future, in the future compared to the fossil fuels, especially about the impact and the risk about the climate change issue.
Okay, thank you for the question, even though that I will not answer specifically to the energy law because I have no knowledge in that area. I want to give a very brief explanation about how law contribution to the legal system. So if we talk about, or we discuss about the legal system, it reminds us to the thought of the Lawrence Friedman, the element of the legal system. So there are three elements of the legal system. The first one is the structure, and then the second one is the substance, and the third one is the legal culture. So in whatever situation, in whatever law, I think each of the elements will play an important role to shape the legal system in each country. I think that the first two elements, the structure and the legal substance, are quite easier for us to plan. For example, if we want to promulgate, or if we want to form a specific legislation, it can be planned. For instance, we know that Indonesia have a Prolegnas, Program Legislasi Nasional, or the National Legislation Program. So, and also in terms of the legal the legal substance, it means that the government can form a specific legal institution in Indonesia. So it's quite easier. But the most difficult thing is about the legal culture. I think that the legal culture cannot be planned, or every country have the different legal culture. It is quite interesting how Friedman gave an example in order to understand each of the elements of the legal system. He said that if we talk about legal structure or legal structure, we can imagine it like a car, look like a car. So if we want a car, each car has its own machine, and a machine, it refers to the legal substance, and a car refers to the legal structure. But if we want to turn off or turn on the machine or the engine, that's referred to the legal culture. So if we want to make a law living as a living law, or if we want to make a law die, it will very heavily depend on the legal culture. So we can transplant, Professor Ningrum talk about the transplantation. The transplantation, the legal transplant, may be a bit quite easier from the perspective of the private law. But if we talk about the public law, in particular, the constitutional or the administrative law, is a bit quite difficult, because there are a number of factors that should be considered. And the first factor that played a very influential role is that the ideology. Because each country has their own ideology, and ideology cannot be easily be transplanted to other country. So this is what I can explain briefly about how law contribute to the development of legal system in a country. Thank you, moderator.
Thank you so much, Professor Susi. So you're emphasizing that the legal cultures is something that cannot easily be transplanted to the legal system, especially when this kind of legal system should adapt or change due to the situations or the emergency situations. Yeah, thank you so much. And now I give the floor to Professor Marsudi as the expert in environmental law. Probably you will respond with regard to the renewable energy in the future compared to the fossil fuels.
Yes, thank you, Bu Diajeng. And yes, I agree with the explanation of Professor Susi, because the question is about the legal system. Yeah, I think precisely what Professor Susi explains about how the legal system could support the changing or shifting, yeah, from we depend, yeah, to the fossil energy into renewable energy. But the question is excellent, I think. I think it is the time, yeah, for us now to change our mindsets, yeah, from fuel energy into renewable energy. And yeah, I think this should be discussed later in a special forum, yeah, because this problem is quite big, yeah. So I agree with Professor Susi explanation. Thank you.
Thank you so much for the response, and I hope it answers your concerns, Pak Joshua Hari, and thank you so much. Again, thank you so much, the audience, for your very wonderful questions. And now I think we have to come to the end of the sessions of these panel sessions. So I don't like to sum up all the presentation from the panelists, because I believe every panelist have a very interesting presentations. I believe all the audience also have taken notes with regard to the important points that has been raised by the panelists. So I just want to wrap up my panel sessions by asking each of the panelists one question, and please answer it in just 1 minute. This question probably nothing to do with the topics, but still have a relations to the COVID-19 pandemic. So for the first questions to Professor Irene, I'm very curious, Professor Irene, what your most productive things that you do during your self-quarantine? You have 1 minute to answer the questions.
Can you repeat, because I couldn't hear you very well?
Okay, sorry. So what is your most productive things that you do during your self-quarantine?
Well, I think that really made me finish several books that I couldn't finish before, because you get pulled in so many directions. But the fact that we were confined at home really made me finish a big book on methodology, research methodology in intellectual property. in which, in fact, one of your colleagues, Miranda Rizang Ayupalar, was one of the authors that wrote for the book as well. So that was my main achievement. A thousand pages book came out of the first few months of pandemic.
Oh, okay. So, is it 1,000 pages of book is a very thick one. And
Yes,
one
yes.
of our senior lecturer, Ibu Miranda, is one of the author of that book. Wow, it's a really great honor also for the Faculty of Law to have the one of the authors in your book. So, that's a very interesting one. And I have another question for Prof. Susi. Okay, Prof. Susi, I'm very curious whether in this pandemic, is there any of your specific personality that dramatically changed because of this COVID-19 pandemic? For example, you become very paranoid to go outside or to meet people. So you have 1 minute to answer the question, Professor Susi.
Actually, this is a very difficult question for me because it is not quite easy to answer your question. During the pandemic, I have to care of my family. I have to limit the relation with other people, and in particular, I have keep an eye to my daughter, and she. Why Ibu, I cannot meet with my friend? Yeah, because this is pandemic. If we are sick, it is very difficult for us throughout this family. So I think that that's make a quite a big change. Yeah. In my personality, I'm very suspicious if my daughter get cough and then get the flu, and me myself and also my husband, then we just I hope that it is not a virus that attack us to our family. So I become very suspicious. That's one of the things. But during the pandemic, I just discussed a small discussion with Professor Ningrum. I have an opportunity to take care of my flower, also as with my other domestic duties, such as I have to what is masak, for my family, and I enjoy that kind of event.
Nice. So at least there is a positive impact from this pandemic, because this pandemic also make everybody's life difficult, and at least we can get some positive impact from this pandemic. Thank you so much for the answer. And then for Professor Ningrum, I'm really curious what things that you like most in this new normal era. For example, now you have experience in online teaching, and you prefer online teaching now rather than the offline teaching, or I don't know, maybe you have some specific answer for that. What things you like most in this new normal era?
I thought you were going to ask that questions from Professor Susi to me, because I rather have the same questions. Now, okay. First one is I'm a clean freak. So I clean up my house, I think 5 times a week, and that kills my mate. Nice. Because I become very snappy and, not paranoid, but it's just to consume my energy. Okay, flowers, done. Cooking, done. Take care of my 2 dogs, done. What else? Clean up the house, just because you cannot go out. So it's my mate become devastated because I became a clean freak. That's the first one. Your question is, I don't know what's happened with all the collection of the what you call this, the mask now. Yeah, it's I rather look at it into business. People are so innovative about putting people like Ibu Moderator who's wearing hijab. It's a business. It's not merely aesthetical to see people with this. But now I wonder what happened to zillions of masks in the whole world with new creations, with new styles, and whether the price is going to drop down, whether they're going to waste it, whether they're going to collect it.
That is my curiosity. Thank you.
Okay, thank you so much for the very interesting question. So now I know that you are one of the you have a like germophobia because you now become a very clean freak during this pandemic. Thank you so much. And then my last question for Professor Marsudi Triatmojo. It's a bit it's a bit very interesting questions. I'm just wondering whether you are pro with COVID-19 vaccines or you rather an anti-vaccines, and please give the explanations why. You have 1 minute. Do we have the Professor Marsudi with us now in this room?
I think it's gone.
Oh, I think it's already left the room. Oh, so sorry. Okay. And then Professor Ian also have to leave the room. So okay, now I have to. So we are just about out of the times. And then again, I want to thank to all the fantastic, amazing panelists for sharing with us all your amazing thoughts. Thank you so much also for the audience for your wonderful questions, and also thank you so much for the organizer for inviting me as a moderator. Again, I'm very sorry that I cannot come in person. Sorry for this inconvenience. So please give one more big round of applause to all the panelists, the organizers, and the audience. And then I will give back the floors to the MC. Thank you so much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Thank you, Ibu Diajeng Wulan Kristianti, for leading our plenary session. And also thank you for all honorable speakers that has given the insightful material for all of us. Lastly, thank you for all participants that has joined this event from beginning until now.
To all speakers and moderator, please stay at the stage because we will present token of appreciation for all honorable speakers and moderator who will be delivered by Dean of Faculty of Law Universitas Padjadjaran, Bapak Idris.
Di sini Pak Deka.
Iya, Bu. Terima kasih. Prof, di sini. Ya.
Moderatornya di rumah.
Ya. Prof, thank you so much.
Terima kasih ya, Prof.
Amin. Prof, thank you so much. Wow, very clear.
Thank you, Bapak Dr. Idris. To all offline participants, we are going to inform you that there will be a gala dinner at 5 p.m. at Bandung Giri Gahana. Therefore, if you are interested, please stand by at 4:30 in front of this building because the organizer will provide the transportations.
Thank you for your presence. Have a great day and
See you on the next day.
Mau nanti di BKS kan?